I leave it.
Thank you very much, Benjamin. I hope it's not too early in the morning for everyone, but a bit of legal institutionalism, but I hope I can wake you up. Some of this will be familiar to you, so particularly the first half, where I will talk about what we mean by legal institutionalism. And then the parts 4 and 5 are illustrations. You can think of other illustrations, particularly, for example, Katharina Pastor's work on legal theory of finance and so on. But what we're trying to establish is a broad approach which takes law into account. I'll explain in more detail what that means. Based on an article with my colleagues here, published recently in the Journal of Comparative Economics. Okay, there's two major ontological claims. One is the nature of law. This claim is that law necessarily involves both the state, broadly construed as the realm of public ordering, and private or customary arrangements. Reduction of law is just one of these two aspects is mistaken. Law involves institutionalized judiciary and legislative apparatus. Okay, there's complications here. One complication is the distinction between state law and public law. We can discuss this in more detail, but I think that when you have a legal system where the state's playing a role, which is the kind of legal system we're concerned with, public law is basically an alter ego. It's a sort of zone within this framework created by the state. There's an important distinction, which I'm not ignoring, but what the emphasis here is on the role of the state. What this means is that law is more than custom. The key claim by Hayek and other kind of spontaneous order theorists is they want to see law as universal and custom as an exemplar of that in a pre-state phase of human society. On the contrary, the claim here is that the creation of states, which is relatively recent in human history, is a key factor, and these enable the possibility of legal arrangements with a judiciary and judgment to different degrees of fairness or democracy or legislative cohesion or whatever. But we know law was almost as old as states themselves. If you read Hayek, for example, I mean, he's my key opponent for some of this. Hayek and some of the Hayekians say that if you mention the state, if you're saying the state's important in law, you're a legal positivist, which I think is a misreading of legal positivism. And what is important to emphasize is that while saying that the state is important, we're not saying the state is everything. So the riposte that state diktat is insufficient to enforce law and sustain a legal system, of course, is true, but it doesn't undermine its argument because we have both arms of the process. We have customary arrangements and we have statutory arrangements. And this is true for both common law systems and civil law systems. They may put different emphases on different aspects of the story. For example, in common law, there may be processes which in some cases are more bottom up. Laws become established because they're already customary arrangement and become statutory in that sense. But that kind of thing is not entirely absent from civil law systems either, through matters of interpretation and inclusion and using examples. So this is true for both arrangements, both rely on custom. If law is to work, it has to be ingrained in practice. At least authority relationships have to be ingrained in practice. The law draws on both custom and authority. Not for all human history, but as long as you have legal systems of the kind that we're talking about. And the second claim is the role of law having been construed in the previous way. Law accounts for many of the rules and structures of modern capitalist society. Not all of them, of course, some of them are traditional and whatever, but many of them are important, like the corporation, like the market, like property and so on. And law is not simply an expression of power relations, but also a constitutive part of the institutionalized power structure and a major means through which power is exercised. Now, this is contrary again to the Hayekian and other kind of Austrian or libertarian approaches. It's also contrary to Marxism, okay? So it has antagonists on different parts of the story. I think it's rather surprising that Marxists don't see law as powerful. I mean, why don't they see law as powerful? They see it as epiphenomenal. They see the power as something else beneath the law. But I think it's important to understand that law is powerful because, not simply because it reflects other power relations, but it also adds dimensions of its own, Weberian legitimation and so on. People obey the law because it has authority, because it's seen to be legitimate. It relates to the perceived legitimacy of the power apparatus, the political system and so on. And when that breaks down, law breaks down too. The other thing to observe is that this is historically specific. We're not trying to make a theory here which is true for all human society. We're trying to make a theory here, or an approach, develop an approach that's relevant to modern societies or legal-based societies, in particular modern capitalist society, where law plays a crucial role and where law has a particular character, where it's more or less, people are more or less equal under the law. One question raises, why do people resist these arguments? One possible answer is that they want a universal theory. The tension in social science between universal theories and particularistic, historically specific theories is as old as social science itself, hundreds of years. And this, I've told this story in one of my books, How Economics Forgot History. It's also a tension in sociology as well as economics. It doesn't mean we abandon universal principles. There are some universal framing principles, there are some relevant things. But the social formations that we see in the last few hundred years are so important and so distinctive and so specific that we need to understand them in their own right and what they add. You could say also for the rise of modern civilization, or rise of civilization, which is a matter of, 10,000 years or so. So there's nothing wrong with combining some universal principles with historically specific recognitions of what's important, and this is a historically specific approach. Nevertheless, it's vital, I think, to understand what's going on. So law means power. So to put law into the picture is to add dimensions of power. There's other dimensions of power, there's persuasion, propaganda, politics and so on, but law itself is power, recognition of the authority of law, and also the force that lies behind the veil of the legal system. If we break the law, potential force can be used, and these are all actual or potential expressions of power. So it's also very important to understand power relations. As I said already, but I emphasize, the second ontological claim applies primarily to modern developed capitalist economies. But there's a complicated story here. What about other economies? Most of the world is underdeveloped, okay? It's important to recognize that. And so understanding and analyzing most of the world, apart from Europe and North America and one or two other places, we have imperfect, semi-developed systems of law, semi-functional state machines all over the place and so on. Is it irrelevant? Well, I think it's more complicated. There's other things going on, but even in these cases, where the law is compromised by corruption, arbitrary power, propaganda, coercion, whatever, or the people ignoring the law, just carrying on in customary arrangements, the law still plays an important role. I mean, take for example a developing African country like Nigeria. I mean, you'll have a mix there of particularly a rural-urban division between areas of society in the rural zone which are ruled by tribal custom, by and large, with the occasional incursion of legal powers. And then you'll have an urban setting where you also have tribal custom, but you'll have a stronger presence of a financial system, financial markets, and some of the engines of development that we see in African countries going on. So there'll be combinations of these things. This makes life complicated, but it doesn't invalidate the basic argument about the importance of law. And we have to understand the cases where law is absent or compromised or corrupted, just as much as we have to understand the cases where it's less so. There's a second set of ideas which this antagonizes with, which this stands up against. And this is the idea of spontaneous development of law. Now, these are not the same thing. Saying that law is basically custom is not the same thing as to say it's spontaneous. But often there's quite a big literature on how legal, so-called legal rules, they call them legal rules, develop spontaneously. And some legal rules do. In fact, you could say many. Historically have developed spontaneously. Some forms of property rights developed by customary arrangements, then became established, then codified and inscribed in statutory law. Trading arrangements, all these, and they're very interesting and important examples. But so when the empirical evidence here is where it's sustainable, and in many cases it is important. But it's important to understand this cannot be used to undermine the notion or the importance of state law and the relevance of legal power. And it'd be wrong to say the power law derives from custom alone, and to downplay the legal power of the state and other factors. For example, in, let's say, Greif's study of the Maghreb traders, this is a discussion of trading arrangements in the Mediterranean area in medieval times, where the Mediterranean area had no single power authority. And Jewish traders established trading networks, effective trading networks, by reputation. So they enforced the members of their own community to follow contracts by the reputation. So reputation effect is, so it was important for them to sustain the reputation of being trustworthy and honest and good traders for other communities. And through that mechanism, they enforced discipline on their own group. And that's an important mechanism which helps sustain law where state law is diminished, and also where it's there, reputation's also important in state legal systems. What it cannot do is replace the importance of state law. So sometimes this is not explicit, but there's a kind of subtext, as reading between the lines, people are saying, well, we don't need the state. So if you stretch these arguments to the claim, a kind of libertarian's claim that you don't need the state, then it rubs up against these arguments here. So it contrasts not only with spontaneous and exclusively custom-based notion of law, but with a Marxist notion of law of superstructure. So this is the proletariat here, and the bourgeoisie, and then the armed, and then the law is just on the surface, and that's the monarchy and all the rest of it. This is the sort of 100-year-old cartoon, the pyramid of the capitalist system. This is the conception. Law is on the surface. It's just there to give. And also religion and law together here. They just sort of sanctify, they just sort of give authority to the power relations which are expressed here. This is again the epiphenomenal view of law. So it's so this point of view actually contrasts with two strong intellectual traditions. One is the libertarian analytical tradition, and the other one is the Marxist one. Okay, so into more detail, that was an overview. Is custom always law? Well, this is a long tradition of putting the emphasis on custom from Hume, Henry Maine, and up to Hayek. And for example, Hayek holds that law is older than legislation, and law in some sense is coeval with society. There's a long discussion of this, legal anthropology and so on. And it's you can have a controversy about whether sort of tribunals of elders in tribal society are a proto-legal system or a proper legal system. But I think the essential point is that while there may be similarities within tribal society with modern developed systems of law, the modern developed systems of law are qualitatively different from these things. On the spontaneous emergence, One of the analytical problems of this is that while they work in particular settings, they typically rest on relatively small numbers of agents and downplay complexities and uncertainties. So, or they rely on reputations of identifiable groups. So the Maghreb traders are identifiable by their Jewish customs and dress and so on. So there's a Jew, we can trust trading with that Jew because they have a reputation for being trustworthy and so on. So you have to have these indicators. Without such reputation markers, the small numbers is required, condition is required, because you need to identify people and say, well, I recognize you from a previous trade. With a large number of people, you can't do that. With difficulties with anonymous trade, with large-scale interaction, a lot of these mechanisms break down. The argument here would be, from a legal institutionalist perspective, is that these growing complexities and uncertainties are a reason why state law developed. Another example here would be the merchant courts, which existed. I mean, up to about the 16th century in Europe, later in some countries, you had independent courts. You had courts which were separate from the state judiciary. Some of these were run by merchants and so on. And why did these disappear? Why did these fade away? Why were things centralized more and more in state courts? The argument would be that it's actually the growing complexity of the processes involved and the need to get legal templates which applied across the board and to transmit learning information which in legal systems about particular cases which required a centralized system. Another problem with spontaneous arguments is a kind of critical mass argument. We do know that spontaneous mechanisms can work, but they have to overcome, they have to overcome a critical mass problem. And that is, once you have compliance with a emerging prototypic order, you have to give incentives for people to comply with it. And the benefits of these orders are proportional to their scope and extent. So when they begin to emerge, they're not that effective. So you have to assume that they've grown to some size before they become effective. So a newborn order cannot yet confer its advantages because it lacks a critical mass. So there's a critical mass problem. Sometimes it can be overcome, but again, this is an argument why in some cases the state had to step in and develop these systems. One particular cases here would include things like legal arrangements for credit systems. These were developed under common law systems in England for centuries, but they didn't work, and eventually they had to appeal to statutory legislation to get them to work. Another example would be corporate limited liability. Very difficult to see how that could emerge spontaneously. It required statutory legislation. So lots of examples like that suggest that critical mass problems couldn't be overcome and it required some state intervention, while in other cases the critical mass problem was overcome. Quite often private legal systems, when we find them, they don't emerge from nothing. They actually build on preceding arrangements, whether they're customary or otherwise. Or sometimes people copy legal systems which exist elsewhere. For example, one favourite example of the libertarians is the legal system in Iceland in medieval times. But you could argue that the legal system in Iceland was a copy of the Norwegian system by and large. It was relatively decentralized, bottom-up system, but it's the fact that it worked for some of the time meant that they were copying, transferring legal customs and rules from the Norwegian mainland. It's important to note that the criticism of the entirely spontaneous view of law is not confined to, it extends beyond some of the people and includes people like Coase. I mean, Coase and the Coasians are often seen as the arguments for, through the Coase theorem for some kind of privatized arrangement. But Coase himself had a different view. When the physical facilities are scattered and owned by a vast number of people with very different interests, the establishment and administration of a private legal system would be very difficult. Those operating in these markets have to depend, therefore, on the legal system of the state. I think he's hinting there crucially at the problems of complexity and scale, which require state involvement in the legal system. And these kind of statements are ignored by a lot of Coase's fans. But back to Marx again, in a little bit more detail. The superstructure metaphor in Marx is not the only one he uses, but it's perhaps the most famous one. The base is a totality of the relation to production, which constitutes the economic structure of society, the real foundation on which arises the legal and political superstructure. So property relations are merely an expression in legal terms of these relations of production. Now this begs the question of what you mean by economic structure, okay? Is there something economic which is separate from and independent of the legal, and the legal is simply an expression? These questions aren't addressed and not answered in Marxism. The legal institutionalist view would be that the economic structure, at least in modern capitalist society, is inherently legal or partly legal in its own character. Critique of the political economy, it's always necessary to distinguish the material transformation of the economic condition to production and the legal, political, artistic or short ideological forms. Well, the argument here is that law is not just ideology. And you can't really separate the economic from the ideological either, because the economic involves human motivation, involves human conceptions about what's possible. Marx is dichotomating the material from the ideal, whereas in fact social and economic reality are always a combination of the material and the ideal. Different metaphor here in capital. The judicial relation whose forms the contract is something that mirrors the economic relation, where this juridical relation is itself determined by the economic relation. Again, we have no definition of what we mean by economic relation. Okay, so if we have an exchange, is that an economic relation, and can it be understood without using legal terms? I don't think it can. I mean, this exchange involves transfers and reciprocal obligations, and the powers making these obligations realizable are legal powers. We simply can't get rid of that. So I think the arguments here of Marx are really, if you push them, are really quite wanting and depend on a false dichotomy between the material and the ideal, whereas social reality is a combination of the material and the ideal. They're intrinsically bound up with one another. The economic does involve ideas as well as material capacities. I made this point yesterday. This is a definition of social class. So if you define social class, this is Engels' definition, notice owners, employers, having no means of their own, selling and so on. All these terms have to be understood, at least in legal terms. So you cannot define bourgeoisie or proletariat without, in Marxist framework, without some reference to law. So I think this is a fundamental problem in Marxism. Marx, again, the owners of merely power, the owners of capital, and the landowners. So unless you reduce land ownership to mere possession, okay, which removes questions of rights and legitimacy, then you have a problem with this, and there will be a problem in doing so as well. This is, I don't know if you've heard of this guy, Svetoslav Petrovich. He's Eastern European emigre, but he's a libertarian economist. Interesting, he edits this book, The Economic Foundations of Property Rights. I suggest that actually this is he's not a Marxist, but he comes from a Marxist history, and this is reflecting. So what does he mean by economic foundations? And how are they constituted before property rights are built upon them? Again, the economic is taken for granted here. It needs to be defined. By contrast, it's simply by looking at the title of the book, Legal Foundations of Capitalism and Commons. So I would say Commons is an early legal institutionalist. What's important, as I've highlighted already in discussing Marx and others, is that property must be conceived as more than merely possession, in a sense of simply having the capacity to control. And this distinction goes back to, it's in Roman law, but it goes back, it's emphasized by Hegel, Proudhon, and others for various purposes. One of the key articles, the classic articles, is Honore, famous British legal expert. And great quote here, to have worked out the notion of having a right to, as distinct from merely having, was a major intellectual achievement. Without it, society would have been impossible. In other words, the legal systems establish rights. And doesn't mean these rights are just or good or appropriate, but they bestow rights, and they back these allocations of rights with powers, ultimately with the threat of force. And because legal systems are built upon or depend upon political systems, and political systems have power because of perceived legitimacy by some Weberian mechanism, these powers are more than the threat of force. They're actually to do with people's conception of what's legitimate and appropriate to do. And this is entirely missing from Marxism. It's entirely missing from the economics of property rights, because the economics of property rights, so called, is entirely about possession. Honore, again, a people to ownership was unknown or recorded a minor part in their arrangement, who meant by me and Tim no more than what I or you presumably hold, would live in a world that is not our world. So Honore is underlining the transformation that occurs with the legal system that bestows rights. So going to the so-called economics of property rights, this dates back to von Mises and Armin Alchian and so on, have definitions of property rights. The probability that the decision about demarcated uses of the resource will determine their use. And that's the definition of property rights. Okay, so I would say it's not about property and it's not about rights. They're both absent from that formulation. And what this means is if I steal something, right, if I steal this computer or I run away and I run a bit faster than I can and get onto and escape the country with that computer, it's mine, okay? Because I've stolen it successfully. It'd be difficult to get it back. Difficult or expensive to get it back, and because I, with a high probability, will continue to control it, that computer would be mine. Okay, it's not. I've stolen it. Okay, there's simply no recognition of the difference here. And there's other definitions as well. In the so-called property rights theory of the firm, Grossman and Hart, ownership is substantially the same as possession again. And this led to the comment, which I think is very true, by Michelli and Luc, much of literature and economics rights remains ignorant of property law. And that's still true. Now, my illustrated example is law and the firm. And there's a set of problems in the theory of the firm which have been thrown up in the last 50 years or so, which I think are soluble in this framework. Okay, so the problems are, one of the problems is simply defining the firm. What do we mean by a firm? And then there's basic questions which everyone recognizes as important. Is it why they're firms in place A and why they're not firms here in place B? So why do firms exist? And what determine the boundaries of the firm? Okay, so what's the nature of the firm, its boundaries, its reasons for existence? These are the fundamental questions in the theory of the firm. And of course, Coe's 1937 example is a very classic and early attempt to answer these particular questions. Okay, and what he does in this article is talk about entrepreneurs, and the whole approach concentrates on the input, contracting, and administrative functions of the entrepreneur. So, entrepreneur is a personal group, and then they're contracting. But the question then is, who is to be sued if the output of the firm produces, is it effective or dangerous? Is it the entrepreneur group? If so, how? This question is ignored. For there to be a firm as opposed to a series of bilateral contracts, there must be some entity that is the locus of legal liability. And Coe's never gets to the grips with it. He simply uses the entrepreneur. There's a group or an individual, and that creates the glue which holds the firm together by definition. But the glue question is really important to say what we have particularly in large firms, a number of people performing entrepreneurial functions. What makes them an entity, a single entity? And a root of this approach, which is called the transactional cost approach in Coe's, is this assumption that he concentrates on the input, contracting, and administration functions of the entrepreneur and never establishes the firm as a legal entity. Okay? So if you think about the legal status of the entrepreneurs and managers, then you can begin to answer those questions, but he never does. And the same problem appears in Williamson. And because there's nothing to keep this group of entrepreneurs together or to show that they constitute a single entity, the whole thing dissolves. So by quite a bit later, it's 50 years later, but 51 years later, Coe's argued that there can be markets within firms. So the firm begins to disappear, it falls apart. So the original 37 distinction between a firm and a market dissolves because there's now markets within firms. Okay, and Williamson continues with this problem. So he says, so he's now talking about a continuum, so sort of a dichotomy, two spaces, market versus firm. There's degrees of marketness and degrees of firmness. Again, not defining what a firm is. What defines a firm at the end of the continuum? I take the defining characteristics to be incentive intensity, administrative control, contract law. Firms combine relatively low power incentives. So Williamson goes into more detail about the structure of contracts, the nature of the contracts. And markets are polar opposites, markets and firms are polar opposites, and hybrids are located in between. And again, the social self-focus is on the internal contracting organisation of production. Okay, and this is common to Coe's as well. So when the co-author of his paper, Gindis argues many thorny questions that plague the literature on the theory of the firm, including key issues related to the ownership boundaries and the inter-firm authority, are due to the fact that contractual theorists of the firm have generally overlooked a key legal feature of the economic system, without which the theories of the firm are like Hamlet without the prince. So what is this key legal feature? The key legal feature is the legal personality of the firm, established by its legal incorporation. Okay? There's a difference between firms and corporations. Not all firms are corporations, but let's ignore that for a while. We're talking about corporate status. And what happens here? A firm is incorporated by registration under a legal system, and it has to have statutes in accord with the legal system under which it's incorporated, which make it treatable as a legal personality. So the law then treats that as a person, treats the corporation as a person. Well, some people say, well, this is just legal mumbo-jumbo, it's just fiction, it's just on the surface, it's false. Persons have to be individuals, all these counter-arguments, they all miss the point. Etymologically, person means mask, okay? So it's a perfect use of the etymologically understood term person. The corporation adopts the mask of an individual and can stand up in law, can stand up in court as an individual. It can sue and be sued, and that creates its unity. So when I buy a hamburger from McDonald's and I puke up at night because I'm sick, I'm not saying hamburgers, I don't want to be sued here. Imagine it were true. Who do I sue? Do I sue the cook in the local McDonald's, or do I sue the person who served it, or try and find the person who didn't wash their hands when they dealt with it? No, I sue McDonald's, a legal entity, not a particular person, because it's their responsibility because they are incorporated as a legal entity. And that is what creates the unity of the firm, the structure. That's what creates its boundaries. That's what makes it impossible to have markets within firms. I mean, firms can subcontract things. You have sort of things like Benetton and Marks and Spencer, which subcontract out and may have competing subcontractors, but that's one firm contracting with other firms. So all these questions about boundaries and identity are solved once you bring law, in corporate law into it. And there's a long story about people approaching this insight, then rejecting it and not doing it. But so I would suggest that this attention to legalities actually resolves many of these problems. It's one of the things, the North Wollaston Weingast book, a very important book, flawed but important. It's the last book of North before he died. And that Violence and Social Order is called. One of the unnoticed themes in that book is the stress on the importance of incorporation. He talks about open access societies, and he says in open access societies people need to be organised. Now it's meaning to be conscious of atomistic individuals preserving the open access of that order. We require powerful groups which are contesting, countervailing power and so on. This includes political parties and include corporations, business corporations. And without those powerful groups in multiple units, you can't have open access orders. And this has been completely ignored to the exceptions to the argument. So this is recognised in some places. Okay, to sum up then, legal institutions shares with other institutional approaches the common emphasis on the importance of social rules. So social rules generally, okay? Informal rules as well as legal rules are all important. Customs are also important. When we understand organisations, we don't simply understand them in terms of the rules that are written down. Customary arrangements, things imbued by the culture, the way people interact with each other, in all sorts of ways are also important. But it adds a further claim that many of the more important, powerful rules are legal in character. And they are backed by the power and authority of the state. So this is not to say everything is law. Emphatically no, okay? The other things are also important. So I mean, all these studies in a business school, people talking about, you know, can you transplant the Japanese corporate form into the West, and what happens when you do it in Italy and do it in Germany, and there's different cultures, do they work in the same way or do they meld in? That's all interesting and important, and maybe you can't do it exactly and you have to recognize the different cultures, okay? And the different cultures are important, and they may not be codified, they may be codified, there may be other problems involved. The emphasis on the legal does not diminish those other things. They're also very, very important. It's surprising how many people think that what this argument means is just that law alone is important. No, it's not. You're being too formalistic, I hear from critics. Okay, I am being formalistic, but I'm also recognising the non-formalistic. So why are you ignoring the formalistic? Okay? Because of these other approaches which have prevailed, including Marxism and sort of libertarian economics, the formalistic is being ignored. One of the implications of this is the literal impossibility of complete deregulation. We're always going to have rules. And some of those rules are going to be legal. We kind of have a regulatory vacuum. So really the choice is what rules, what frameworks. all this discussion about neoliberalism and the sort of rise of neoliberalism in the last 40 years, which is an emphasis on market orders, an emphasis on privatization. Whatever you think of that, this position would argue that even an extension of markets requires legal frameworks. So you can't ditch or subdue or get rid of or strip away the legal aspect of the story. Also, by its obverse, legal institution highlights the importance of corruption. I hinted at this when I talked about less developed countries, contemporary less developed countries. If corruption is about breaking rules, okay, there's a broader meaning, but most studies of corruption, Transparency International Index and so on, business corruption, these are about people breaking rules, either corporate rules or private law, or also state law, by bribery, other things. Now, if rules are being broken, if law doesn't work because it's being undermined by corruption, this is important. So this becomes an important thing. It's rampant in developing countries. So, for example, China. It's an article I read with a Chinese colleague about corruption. China is a foremost example. The question is, to what extent can China develop based on a highly corrupt legal system, which is fused with politics, with a one-party state? Attention to the need for a relatively autonomous and relatively uncorrupt legal system becomes an important question for Chinese development, both for empirical inquiry and also understanding the kind of problems down the line. So the rule of law is crucial. This is an empirical, a very quick and rough empirical investigation into this. And this is in the Conceptualizing Capitalism book. Vertical axis is non-oil GDP per capita, okay? Why non-oil? It's non-oil because I originally did it with including oil, so just basic GDP per capita, and noticed that a lot of these countries, as it was before, were oil-rich countries. And there's a justification for that, is because there's strong correlation between strong resource endowments and corruption. There's literature on that. So if you remove it, you get a higher correlation, so it kind of supports that particular thesis.
Who's the outlier?
The outlier here, I think that's maybe Hong Kong or Singapore. I've forgotten. It's in the book. This is two things. Again, it's quick and rough. Degree of open government, so it's an index of democracy, and the absence of corruption is a corruption index. This is from the World Justice Project Rule of Law Index. There's several databases you could use. I've used different ones. You get correlations to other ones, but this is a relatively well-respected one, which is not part of the libertarian network. While I used some of the other data for things, I think it might be challenged if I simply from a libertarian perspective. But you get this very strong correlation, adjusted R squared 0.776. And what this means is that to move upwards, to improve oil GDP per capita, it's difficult to do so without also reforming in this direction. So countries like Russia here have got further than most in terms of GDP per capita, and it's unlikely that they can get further up here without reforming, moving to the right. By the way, Russia is probably up here because of gas. I couldn't get figures on gas. So put all fossil fuels in here might redress that issue. Anyway, it's rough, but it's an illustration of the fact that there's some empirical evidence that these things are important. How does it stand in terms of the two traditions of original and new institutionalism? The new institutionalism was a term invented by Williamson to refer to his work, Coe's, North, and several others. The original or old institutionalism, particularly in America, was Veblen, Commons, so it was 100 years ago, and in the interwar period as well. Now, some people think that these are very different beasts. They're not, actually. They're internally just as different as they are variant between each other. And there's strong overlaps, for example, with North. But anyway, what's the relationship? Well, I could put these four people up. Geoffrey Brown is one of the entity theorists of the firm, a legal entity theorist. He fits into neither of those traditions, but he's an example, one of several. There's some German writers as well also writing about the firm as a legal entity, which you could add in. There's one example. Most prominent, as I mentioned already, Commons would be a prominent example of a legal institutionalist from the original tradition. And we have a lawyer like Honore. Then we have Douglas North, who's from the new institutionalism, who says things which are also consonant to some degree with legal institutionalism. So there's a mixture of sources. It's not drawn from one tradition. It's eclectic and across the board. So it builds bridges between institutionalisms, and it also criticizes some of the ideas on either side, as I've done. How does this relate to law and economics? There is a growing dissident tradition in law and economics, but the American-dominated stream of law and economics has meant, by and large, selected parts of economics applied to law. In other words, we apply optimizing techniques to legal systems and so on. So we use the neoclassical apparatus and apply it to law. Instead, legal institutionalism is truly law and economics, because it actually learns from law as much as it learns from law. So law is more than a junior partner. Law can tell economists a lot about how institutions work. Doesn't mean that economics is also not without insight. It is. It has important insights. But I think we should learn much more from law, particularly property law, law relating to finance, law, corporate law, and so on. Thank you very much.